Thank you for having me. I'm just gonna try to be brief since it was a pretty long day and it's quite hot and I'm kind of hungry. Not hungry, but hungry. I'm just kidding. um, I would like to pinpoint one abstract idea that comes from my report. It's gonna be rather bigger picture than like this list or yeah, like rather than list of individual institutions. But I think from my report stems one bigger idea. The Czech participatory system is really strong when it comes to protection of violations of rights. It's really strong in its defensive part, but it's really weak in its active and participatory and enabling part. So we have, as maybe Wojciech already left, but as he mentioned, the broad catalogue of constitutional guarantees. I think the Czech constitution is pretty similar, also similar to our Slovak friends. And if you go through the Czech constitution and Charter of Human Rights, which is a Bill of Rights of our constitutional order, you can see a pretty mature and innovative constitution, which is packed with individual guarantees, which is packed with individual rights, and you have pretty much any political right there. And we have also a specific human right to participation, both by voting and by running for the office. So from this point of view, we have really robust constitutional protection system of participatory rights and liberal democracy, let's say, which is then followed by a really dense net of implementing statutes and sectoral regulations on each of these individual rights. So from this point of view, from the point of view of protection of already enshrined established rights, our system is really strong. And it's also strong from the point of view of the judicial protection, because the judicial system works quite well. We normally, I think it's the same to every nation in European Union. We always grant about our justices and about our judicial system, but data shows the Czech judicial system works quite well. On top, well, even though yeah, I would say it's working quite well. On top of that, it's more than average well. So we really don't have to grant about our system. And we have proactive constitutional court, which does not hesitate to wade in, even in situation when political stakes are high. But on the other hand, it's again outweighed with the pinch of judicial restraint, so it somehow balances its position. It's kind of restrained, and then if the stakes are high, it weighs in and strikes down the law, strikes down the statute, strikes down the decision of Supreme Court, whatever. It does a job. So from this point of view, and on top of that, we have quite good record in front of the European Court of Human Rights. We have strong record in the international treaty bodies. So from this point of view, we have no problem when the violation occurs. The system could react effectively, but it's always ex ante reaction. Our system is really weak when it comes to proactive problem solving and policy making. So this is the main idea I would like to pinpoint from the outset. And well, that's it. So thank you for listening. No, I'm just kidding. I would like to delve deeper into that, but I wanted to say it straightforwardly at the beginning of my presentation, because if you want to take something from my presentation, this is the piece of information you have to receive. So, yeah. I've mentioned the constitutional framework and also the dense web of the following sectoral regulations. Well, I've also mentioned that that the our regulation and our legal framework is really focused on the defensive side. So if I have to say that there's one sector when the participation procedures are really working and are really vivid, it's gonna be the environmental and spatial planning law, because in these section or in these areas, again, the regulation and the participatory procedures are enshrined in law, so they're mandatory. They're mandatory and legally enforceable, and this really in Czech Republic means something. Because the rest of the participatory procedures are just voluntary, and you can find them only on regional level, not at the state level. So if I have to pinpoint one sector where really participation works, it's going to be environmental and spatial planning law, both the building law and also SEA and DEA regulations. It's not, again, it's not that it happened somehow, or it was the initiative of our politics. It's because it's implementation of European directives. So it has its reasons. Okay, if we get to the participation mechanism, what really divides us from the jurisdictions that already been presented, we have no national referenda at all. We have no standing scheme for national referenda. Our constitution provides a basis for having such referenda, but it's more like enabling clause. It's not a right to have a referendum or to participate in the referendum. It's like enabling clause, and by this I mean that the constitution just says that when people are gonna if they're okay, and I'm struggling with the translation. It says that if people are gonna be okay, I can just look for the wording. Sorry, just a minute. Yeah, a constitutional act may designate the conditions under which the people may exercise the state authority directly. So this is the enabling clause, and it presupposes a special constitutional act to be enacted, but such an act never been enacted. Or I mean, like the general framework, like the special constitutional act that will set up the general framework for the national referenda. We already had one national referenda, and it was the 2003 EU accession referenda, which was successful, and like 73% of people voted for to be part of the EU, and about 60% of people participated in such a referenda. But apart from that, we have no experience with that, and no standing mechanism, no standing legal framework for national referenda. On the other hand, we have also act on regional referenda. Czech Republic is divided on national level, regional level. We have 14 regions, and then municipal level. And we have act on regional referenda and local municipal referenda. Well, the regional referenda never occurred here, even though we have standing legal framework, but it's more like a political science thing, because these regions are rather artificial. They were found in the beginning of the century, and they're more like, they're not historical units. They're just new administrative units. So because of that, there are no like real vivid connection between people and these regions. So maybe this is part of the story. So, but on the other hand, we have really vivid culture of local referenda. Since 2004, when the legal framework on that was enacted, we had a few hundreds of local referenda, and some of them were also on really important political issues. For example, in 2014, if I'm saying it right, Prague citizens were deciding on banning hazards in the city center, or citizens of Brno, which is the second biggest city in the Czech Republic, decided on relocation of main railroad station. So this is kind of big project with high political stakes and high impact on the lives of our citizens. So yeah, this part of the referenda family is really living, it's really vivid and prospects, I would say. But that's where the fun ends, and the rest of the participatory forms are rather absent in our legal system. If I say they're absent in the legal system, I mean they're absent in the legal system as such. We have no legal rules on them, but that doesn't mean they're absent at all. They're non-existent. But yeah, well, it's somehow interconnected. So if you have no regulation and these forms are dependent only on the will of the politics, so it somehow implies that they're not that frequent as we would like to. For example, we have barely any experience with citizens assemblies. We have, well, I think for the record, there's one assembly that's really worth mention. It's 2011 assembly, which was ran by an NGO in Prague. It was on the climate change, but it only resulted in a recommendation which was basis for further policy adopted by Prague municipality. But it's really the unique experience we have. What is really rising is participatory budgeting. It's since year 2014. This let's say this way of participation is really rising, and again it's a voluntary thing which is dependent on the will of individual municipalities of politics, and its future is also dependent on the outcomes of elections. So we have only a few hundred of the participatory budgets now, and I would say in approximately 60 municipalities. And there's no legislation, therefore there's no like set portion of the budget that the municipality has to devote to this participatory budgeting. Therefore, the practice really varies from one municipality to another. So it could be in small municipalities, it could be hundreds of thousands of crowns to dozens of millions of Czech crowns. So it really depends. As I've mentioned, the most vibrant participatory area is the EIA and CEA regulations, which is the process of assessing of impact of some projects or huge infrastructural buildings on environment, and why this is so important and living and successful is because it's enshrined in the law and it's mandatory. So you have mandatory hearing if there are some relevant objections. You have mandatory public hearing. You have mandatory you have mandatory right to um, initiate judicial proceedings. So it's really strong position for the both general public and both NGOs. So these tools are really in use in Czech Republic. Well, if we get to the legislative process, um, again, the public participation is rather scarce. The government is running the ECLAP system, which is database, where consultations on pending legislation could be provided. But this system is open only to the institutional actors and some selected NGOs. So it's not open to the general public. As I said, it's just the institutional stakeholders. There's a roll-up of a new system, new database, which is called e-legislation, but it will change some technical issues. It will make the cooperation between state organizations and state institutions more easy and easy to use, but it won't change the participation of the general public. So I think there's no change on site. I've already mentioned that we have rather proactive constitutional court that haven't hesitated to wade in, even in really uh, politically uh, politically uh, infused issues. So that's also an evidence of the how the whole system works. That it has a huge puts a huge stress on the defensive part. Also, what is definitely a pro is that we have finalized the reform of and national human rights institution status, and the ombudsman was vested with this position. Well, the ombudsman in our system is more like a catch-all institution. So whenever something has connection to human rights, it's vested in in the ombudsman. And at the end of the day, well, it's okay because it has, the budget, it has the personal aspect, it has the many professionals that are good in human rights protection. So that's pretty much okay. And together with this 2025 reform, the new child's ombudsman was established. And this is particularly interesting, I would say, because when it comes to representation of marginalized group, and children sometimes are marginalized group, especially those in institutional care, this child's ombudsman has uh, a board which is set up only with children. So this is one of the committees that has the ombudsman, and it has like lively experience with the issues the institutional body is the ombudsman, children's ombudsman, is dealing. So this is I think this is a good change. Okay. Some of my colleagues also mentioned the rising of SLAPs, and I have to admit that we're still waiting for the EU anti-SLAP directive to be transposed. So unfortunately, that really weakens the position of the NGOs, of the journalists, and the civic society. So this is again rather corn. Okay. I would skip this. when I've stressed that our system is really good in protecting of uh, of violations of rights or dealing with them, the reaction of our system is mostly judicial and institutionalized, and since we're lacking the proactive part of the participatory framework, um, uh, I think that the public power in our country sometimes deals with these marginalized groups, such as people with disabilities, and especially we have quite strong Roma minority, which is about 2% of population, and these people are underrepresented. They're not. I would say they're not represented at all. They're invisible in the public space. And in many occasions, the public power are dealing these underrepresented people as more like objects of the policy or the regulation, not as a partner who will co-alter the policy. So this is one of also one of the key messages of the report. Uh, because the Czech system recognizes participation more procedurally, but not yet as equality basis. And it really doesn't recognize that, especially with these marginalized groups, you have to be proactive. You have to have a proactive outreach to make things more accessible. And because of that, these people are not represented at all. And if they're represented throughout some commissions. For example, we have commission on. We're good at establishing commissions. So we have commission on everything, like on Roma minority, on people with disabilities and stuff like that. Women equality. Yeah, just imagine whatever you want. We have it. But that's why I've stressed so much the ombudsman, which has the committee or the board composed of children, because in these commissions you have no people with direct experience. You have no people with disabilities there. They're put together by NGOs, by some academics and stuff like that. So these marginalized and underrepresented groups are not part of the whole decision-making chain. So they're treated more like objects here. Okay. Okay, yeah. I'm gonna be heading towards the conclusion. Okay, well, as I mentioned that our system is really courts-based. Courts have really good public trust. 63% of public has a trust in courts. Compared, for example, 9% of general public has trust in political parties. And if we go through the state institutions, the president has about 60% of public trust, then the trust really drops. Then you have Senate with some 30%, then government 25%, and then House of Deputies with only 20% of public trust. Yeah, so this is another piece of information, I would say, that makes the whole bigger picture. And this part draws on the part of the report. This is about constitutional culture, and what was really striking for me was that how I put together some ideas on how constitutional debate is present in the public space, and I have to admit that it's really present. It really permeates the whole public space, and I was kind of shocked because when I was doing my master's degree, the constitutional law was kind of invisible. So, well, from time to time popped up some some crisis or whatever. But it was mainly issues connected to House of Deputies and to voting system, to electoral system. And now the things have really changed, and the constitutional matters are on a day-to-day debate. And I have few hypotheses. It's still hypothesis, but I think they're quite on target. One hypothesis is that deals with the expansion of constitutional matters as the scope of the constitutional rights expands. Also, the constitutional debate expands. Then you have the politicization of the court. Politicians, on many occasions, they brag about the Constitutional Court, but they do not hesitate to bring the case in front of the Constitutional Court as a continuation of political struggle. So by these means, they also helping the politicization of the Constitutional Court and vice versa, constitutionalization of political matters. And the third one I forgot. Okay, but maybe yeah. Okay, so that was, I think, the quite an interesting piece of information that really struck me. I've already said the conclusion in the beginning, so it really facilitates things for me now. So, in short, I would conclude that we have really strong defensive shield of participatory rights, but we are lacking the instruments to actively participate for many citizens and to co-author public decisions. So that's the bottom line, my main message. Thank you for your attention and have a nice day.
So much, Professor CERV, for your presentation. And we move to our last presentation for today with Anna Nochevas.
Thank you very much. Hello, everyone. Thank you for the amazing presentation throughout the day and for the organization, of course. I swear, because I'm the last one, I will make it 15, 20 minutes top to do the French system, and I do swear on that. But still, given our significant constitutional history and the relative longevity of the 1958 Constitution, this presentation will try and highlight the structural core of the French participatory system. I will first outline our constitutional and some sub-constitutional provisions, and then focus on major democratic developments since 1958. I will examine existing but underused provisions, which seems to be kind of the theme today, alongside alternative participatory mechanisms. To start, I will briefly introduce our constitutional history and the Constitution itself while highlighting its participatory aspects. So as some of you know, maybe, the French Constitution was promulgated on October 4, 1958, and it establishes a parliamentary regime with a distinct twist. As Charles de Gaulle was its primary architect, the text heavily reflects his vision, most notably through a rationalized parliament that we call Parlement rationalisé, along with a strong executive and a powerful president of the Republic. When I say powerful, I don't mean that in an informal way, because he does, in virtue of Article 19, have many discretionary powers. And as you're going to see throughout the presentation, the president is going to come along quite a few times, actually. The direct and semi-direct democratic tools we will discuss are a blend of novel 1958 creation and older mechanism stemming from a long-standing tradition of direct democracy in France. Among the structural innovations of 1958 was the Constitutional Council. Some similar entities existed before, but nothing like it. And this council introduced, among other things, constitutional review. Over the decades, the council emancipated itself from a purely procedural role it had in 1958, becoming a vital guardian of fundamental rights. You will also hear a lot about the Constitutional Council throughout the presentation. The landmark 1971 Freedom of Association decision was the first step in its metamorphosis. By giving constitutional force to the preamble in this decision, the Council integrated the preamble of the 1946 Constitution, 1789 Declaration of Human and Civic Rights, of course, and later the 2005 Environmental Charter in its constitutional review, establishing the bedrock for the fundamental rights protected today. Turning now to the constitutional provisions regarding participation, two of the most emblematic ones are Article 3 of the Constitution, and I quote here, "National sovereignty belongs to the people who exercise it through their representatives and by means of referendums." But also Article 6 of the Declaration of Human and Civic Rights, I quote again, "The law is the expression of general will. All citizens have the right to contribute to its formulation, either personally or through their representatives." When you look at those two provisions and when you do a literal reading of them, you could think that the French constitutional framework gives a central role to participation into direct democracy. In practice, however, and it goes right to what you were saying, the implementation of those provisions face persistent challenges as the state remains fundamentally anchored in a representative regime. To complete those two provisions, I will briefly do a list of the four main texts that are within the constitutional review. So I'm going to start with the Constitution itself. Article 1 establishes equality before the law, reflecting a universalist approach deeply anchored in our French system. Article 3, as noted, governs the expression of the sovereignty. Article 11, that I will elaborate on, relates to legislative referendums. And Article 69, in its third paragraph specifically, relates to petition rights. For this presentation, you can go and see in the report, I don't know when the reports will be available, but there are also many provisions on the ratification of treaties and specific arrangements around New Caledonia. I will touch really quickly on New Caledonia at one point, but still it's really interesting in that conversation in general. Moving on to the Declaration of Human and Civic Rights, we find the previously mentioned Article 6, so the law being the expression of general will, alongside Article 10 and 11, which respectively protect the freedom of opinion and expression. And finally, Article 16, which is one of the most important provisions in our system, establishes that a society lacks a constitution if it does not guarantee the protection of rights and the separation of powers. We then move to the preamble of 1946, which features social rights mostly that require more targeted protection. Paragraph 6 establishes the right to a union. Paragraph 7 protects the right to strike, and paragraph 11 provides that some groups are more vulnerable than others, namely children, women, and the elderly. Finally, I wish we had more time to see the administrative side of it, but the 2005 Charter for the Environment introduces in its preamble the right of future generations to live in a healthy environment. And to do that, you can use Article 7, which creates a right to public participation in decision-making processes that affect the environment. Very similar to what you said. From this list, which is shortened from what exists, we see that one of the main strengths of our participatory framework is the variety of tools that can implement more direct and semi-direct and participatory democracy on the national level, but also on the local one that I will develop in the first part of this presentation. Furthermore, the protection of these provisions is guaranteed by the Constitutional Council, but also by the Defender of Rights that you can find in Article 71-1 of the Constitution, who ensure the compliance of rights and freedom of the people by any state-related institution. Another important body to protect these rights is the Environmental, Social and Economical Council that you can find in Articles 69 and following of the Constitution. This council is the third constitutional assembly, usually not as well known as the National Assembly and the Senate, because it's a non-elective one. This council has consultation purposes only and has been trying in the last decade or so to present itself as the chamber of participation. As explained in the report, it played an important role, and even central role, in different participation processes, such as the Great National Debate and the Citizen Convention for the Climate. These two events just mentioned will be described further in the second part of this presentation, but it is necessary to point out through them another strength of our participatory framework, the will of the people. Through our participatory framework, so freedom of expression, of opinion, to strike, to assemble, we have the possibility to develop a counter-participatory culture. This neo-participation gave way to the creation of remarkable democratic feats in the last 10 years, such as the two mentioned. It is important to note that these neo-participative pools also have their own life. I'm talking here of examples where the state does not pick up those events And so they say citizens events. And I'm talking here about Nuit Debout and Notre-Dame-des-Landes. So it's detailed in the report because I didn't have time to talk about it. But it's places where they create entire alternative democratic culture. And it's so unfortunate we don't have to talk about Notre-Dame-des-Landes, but for 10 years they had constructed, in place of when an airport was supposed to be constructed, to go against the states, where they developed an entire democratic city, where they built themselves houses, everything, and they had a system, a judicial system, but no executive and no parliament, because it was a more direct democracy, but still. So they put into place all those new like democratic tools. Fortunately, you can refer to the report on this. From what I developed in this introduction, two important aspects of a participatory system must be considered: the existing participatory instruments and effective use in the first part, but also the alternative instruments of participation and the culture that stems from our constitutional framework in the second part. So part one, existing constitutional instruments and their effective implementation. As explained in the introduction, we will focus our analysis on specific participatory tools and effective use in practice. I decided to focus on local participation, on the rebirth of the right to petition, and on the trust the people have as a result in their institution. First, on local participation, as stated in the report, the use of participatory instruments on the national level can sometimes be quite cumbersome. And most of the daily instruments are on the local level, which kind of makes sense in a country like France because of its size and because of its constitutional system as a decentralized country. Local participatory tools are developed, but sometimes lack publicity as participatory instruments. I decided here to present one of them, which I thought would be very original: participatory budgeting, like everyone else. I wrote it, I was like, oh, this is going to be so original because we don't talk about it a lot in France. And then, well, everyone has it, which is very good. But these budgets are drawn from the self-government of local entities that is enshrined in Article 72 of the Constitution. And they are created as non-binding tools through the local initiative to give the opportunity for residents of a local entity to have a say on the way the budget is spent. It looks like a lot of the budget you described. There is no limits on the amount that can be allocated to it. And it's usually just on project, and it's like cities have their own their own condition, and they can be very different from one city to another. And that gives the opportunity for residents to put forward and vote for different projects that the town hall will then select and put into place as the budget has been voted. For example, through this budget, the city of Paris installed compost bins in various neighborhoods for its residents. So that goes to show that it is really like a day-to-day exercise of participatory rights by the people, because, I mean, compost bins, I think, can change people's lives, but, you know. And other than that, I think an interesting element for our analysis is that the requirements to participate can be extended in those types of local initiatives. For example, where we are used to the 16 or 18 being the minimum age to participate, for that same Paris budget, the minimum age is actually 7. So from 7, you can go and do the proposal for the use of the budget. This instance of local participation is not isolated. Further examples are detailed in the report. And I'm just going to do a very small parenthesis here on a very notable participatory process we have going on in the French framework, and that's the one in New Caledonia. New Caledonia being an overseas territory with a special constitutional status. This process has been going on for more than 35 years, and it derives from Article 72 to 75-1 of the Constitution, which, among other things, governs New Caledonia's institutional status and its path regarding self-determination. This process, which takes root in the will of the Kanak people to gain independence, or at least a form of autonomy, is a very rich mine of examples of diverse participatory tools that can work or fail. So please, again, go to the report to this, but it's a really interesting. I don't have the time because it's 35 years of participatory decisions, but it's very interesting if you have time to look at it. Therefore, the local tools that we can use, represent an important part of our democratic process, even though, as stated before, it is sometimes underexplored, pushing even to rediscover some tools through the years. I'm talking here about the right to petition. It was for a long time only found in the bylaws of the Senate and National Assembly, and it was then expanded in 2008 through a constitutional amendment with the possibility to present petitions to the Environmental, Social and Economical Council, as stated before in Article 69. I'm not going to expand on the conditions because they are quite similar to others and it's detailed in the report. But one very interesting thing about both of them is that they found a second life through the creation of electronic platform since 2020. And that gives the possibility to citizens and non-citizens to go and sign those. And I actually received a link this morning for one of them because there is a petition going around against the nomination of the defender of rights that is being nominated for 6 years by the president. And it has almost 150,000 signatures already in 2 days. So I think the resurgence of this right in this particular example shows that in the last year, the people have been using petition right to go against specific issues, but mainly against specific bills that are proposed, discussed, amended in Parliament and against decision of the public bodies. And that shows that the people are asking for more of a say in the creation of norms, which would, in fact, simply respect Article 3 of the Constitution and 6 of the Declaration of Human and Civic Rights. This need for more direct say in decision-making also stems from a need for the people for more transparency in decision-making. This need has been on the rise and implemented in our system through different institutions, like the High Authority for Transparency in Public Life, but always with a sort of orientation toward the economical transparency of our representatives. These different institutions were to concentrate on risk of infringements by the state toward its citizens, therefore putting these obligations on the administrative level once again, while our representatives and decision makers stay unaccountable for the decisions they make and how they make them, even when the people have used their participatory rights to have a say. We can understand the situation, of course, because Article 27 of our Constitution does prohibit binding mandate, but still maybe we can find solution to those issues. This need for more accountability comes from different origins, but one that is of interest to us is the lack of public trust in constitutional institutions, as a recent survey from 2026 shows. It explains that 72% of the population does not trust in politics, and that only 20 to 30% on average trust the constitutional institution, so the Senate, Constitutional Council, etc., etc. And because of that lack of trust, the people show that they want to be able to have more of a direct say, of a direct participation than it ever maybe before. This lack of trust also comes from the democratic crisis that France, but many other countries and European countries are going through, which pushes citizens to consider alternative democratic ways of expressing themselves. So that is the second part, the alternative participatory instruments. As pointed out in my introductory comments, coming from general constitutional provision and participation, several counter or alternative instruments were developed. We will concentrate on different ways this happened. One of them is the lack of respect for the constitutional text, while another one is through citizen initiative that is then picked up by institutional powers. First, on the misuse of the constitutional provision relating to participation or to direct participation, we need to concentrate on the very famous case of the use of Article 11 instead of Article 89 of our Constitution. Article 11 relates to legislative referendum, whilst Article 89 relates to constitutional amendments. Constitutional amendment can have one of the ways that you can do it is through a referendum in the end, but before that, you've got Parliament that has to agree on the constitutional amendments. And in 1962, to undercut Parliament, Charles de Gaulle used Article 11 instead of Article 89 to present a constitutional referendum to the people. After the success of 1962, he tried it again in 1969, but this did not work this time, leading to its resignation, but also to stopping this use of Article 11 in its tracks. So stopping the use of a direct democracy tool of basically the citizen voice to further political agenda or believe that certain provisions should be in the Constitution. So this use of Article 11 instead of Article 89 is now widely seen as a breach of the Constitution by mostly every constitutional lawyer. And yet, some presidential candidates for 2027 have heavily hinted, or even just blatantly said, that they would use Article 11 instead of Article 89 to revise the Constitution. Here, once again, the Constitutional Council, through its former president, through informal channels, but still, pointed out the only relevant article of the Constitution to amend it is Article 89, and that they would make sure that it was only through Article 89. These questions are nevertheless still open, as the 2027 election and the renewal of a part of the members of the Council, especially its president, will most likely reshuffle the deck. Therefore, misusing our voice, whether for ill or for good. For ill, it seems for now, but now and finally, for public participation and citizen initiative, we will develop the Great National Debate and the Citizen Convention for the Climate, also, of course, developed in the report. The Great National Debate comes from the Yellow Vest movement that started in 2018 because of the surge of cost of living, putting forward an entire fringe of the French population who was struggling to make ends meet, pushing them aside when it came to decision-making, as they lacked the time, the money, and sometimes even the knowledge to partake in it. The grievances put forward were diverse, but all was for better economic rights and a better representation, with the creation or the deepening of democratic tools. This mobilization lasted for months, with the people blocking the roundabout to obstruct the motorway, participating in demonstration or in general discussion on the issues at end. This national mobilization pushed institutional powers to open a conversation. That conversation was opened by the President, Emmanuel Macron, when he organized a great national debate, regrouping national and local inquiries sent by the people and discussed on all levels, amounting to an important national debate. The different participatory tools are developed in the report, but for example, there were emails, there were like local booths, there were so many different of them. And this new organization was an incredible democratic example, but it presented also quite important issues because it was still very much top-down, giving an important voice to citizens, but only through the procedurally accepted mediums of the government, pushing aside entire chunks of the population once again. Another critique, and I think that is one of the general critiques here, is lack of consequences in people's lives after this grand consultation. And actually the same critiques were made about the Citizen Convention for the Climate of 2021. This convention was actually a claim of the Great National Debate, so showing there were consequences to that debate. And it was a remarkable enterprise with 150 men and women randomly drafted from 16 to 80 to best represent the French society. And for 6 months, they met, debated, voted, amended, and met with over 100 professionals on the question and drafted propositions to implement actions to better protect the environment. The president had said he would give those propositions with no filter to the regulatory bodies and legislative body to implement directly. He put a veto on 3 of them, but accepted the other 149 propositions. The problem was some of them were actually implemented, especially through the regulatory rules, but they were watered down to a point that the people that partook in the participation said, we didn't change anything, this didn't change anything. And of course, as you can guess, when it comes to the environment, they were watered down because they had to work alongside converging objectives and mostly economical and development ones. Therefore, the same critiques were made to the Great National Debate and the Citizen Convention for the Climate, a feeling of an incredible possibility to participate, but a lack of effect. Now, just some few words as a conclusion. From what I decided to develop from the report, it could almost seem that our participatory system is widely defective. It is not. It works quite well. It simply lacks some bolts and screws to make it a bit more effective. Some of the main weaknesses first of our framework, and I'll put that very simply because it's kind of the same as we've been hearing today, but is sometimes the difficulty of using those rights when it goes to the national level. And stemming from that, also a lack of education on those rights and how to use them effectively. That being combined with a feeling of being largely unheard, even though we actually use our participatory rights. To prevent those shortcomings and many others, there needs to be a wider constitutional education so that people are more informed on how to use those rights and when to use them effectively. Furthermore, our representatives need to be held accountable one way or another when, and especially when, blatantly going against a widely shared opinion, and consider to its full extent the will of the people when they get given the opportunity or take the opportunity to express themselves, whether through the traditional framework or through alternative democratic channels. Thank you for your attention.
And so I open the floor to question. I don't know if you want to make, we can start with questions, maybe, if we still have the energy to do so. I have personally one question for Professor Mokra from a report, because I read it with a great interest. And there is one point that in my view is interesting, but I want to ask just a clarification. It's on voting rights at local and regional level. Who are the people entitled to vote in those elections? It's just a curiosity, because I read that she mentioned third country nationals. Also in local council?
Yes.
This is a, so I got the point.
Yes, especially in the local level.
Uh-huh.
On the local level, it's more like resident than the provincial.
On the local and municipal level, it's the residency which is the decisive factor. So if you are like Italian living in Slovakia, you have the residency permission. You can vote in the municipal and regional elections because this is the idea because of the directive. But the directive mentioned the EU citizens. But we have it equally for all third country citizens. So when you have the residency permission, even if you will be from Kenya, and you have the residency, then you are over there. There is one small, but it's more like a procedural thing. Like when you are Slovak citizen, you go and vote. Yeah, you change the residency, and you are not on the list of registered citizens. So you came with your ID, and they will just add you to the list on the spot, and you vote. But this is not applicable if you are, like citizen of the other member state or third country national, even if you have the ID, the Slovak one, the Slovak residency, and you came, they will not add you on the spot. Yeah, because it has to be verified by the respective local authority in the list of the registered voters. So that I found particularly like a bit like on the edge of discrimination, because how can you distinguish this is the national, this is the third country national, this is the EU citizen, because all of them have the same ID with the registered residency. But that's how it works. But they still have the right to check the list of the registered voters and ask the local authority to add them on the list before. So it's very much recommended, especially by the public defender of rights, to check if you are the EU citizen or third country national, that you are registered for the particular elections in these regards, and you can do it on the local authority.
Thank you so much. Thank you. That's really interesting, because we tend to consider this when we talk about the citizens' assembly, so the possibility to extend, the possibility to participate.
The local level is deciding on the local administration. Right? Yeah. So it's relevant for those who are actually living there. So that's very good. The citizens who are like expats or like living out. Users, yeah, these kids.
I know that in the Czech Republic, a difference from Slovak one, there is no culture of referendum. Let's say there is a problem with referendum, especially at national level. This is like in the German case for different reasons, maybe. I wonder if you can, if you have an idea why conceptually or theoretically or socially or historically there is this attitude to the referendum in the Czech Republic.
Well, actually, this attitude, maybe I can shout it loud. Oh, maybe there's also a microphone. Well, actually, this idea has its development over time because after the fall of the communist regime, we were really pro-referenda, and but we missed, the gap of the opportunity to establish the framework because in the 90s, I think, as I got it from, don't have the living experience because I was a kid, but when I got to the academic works that were published in these days, they were like really the debate was really active, vibrant, and I think the main tone of the discussion was really pro-referenda. So I think we really missed the opportunity to establish the legal framework. But I present it as the missing legal framework of national referenda as a core of our system. But if I have to present my personal opinion, I'm really not a fan of referenda because as I grow and I see for the experience from other countries, for example, Brexit taught us a lot about referenda. I think the yeah, well, it's really problematic institution.
My question was provocative, in fact,
Uh-huh.
because in the current populist government,
Yep.
I know there is a party, the Okamura party, who has in its program the quest for referendum, especially for some very divisive or polarizing issues. So in certain political context, the referendum can be a very populist instrument, a very polarizing and so also dangerous, with a sort of plebiscitarian attitude. Yes?
Yeah.
While in the case of the Slovak Republic, it has a different meaning because they are a specific section of their constitution about a referendum. So same origins but different.
Yeah, well, actually, as I've mentioned, Brexit, I think this is a really important lesson we have learned from Brexit because as I was going through the Czech debate on referenda as well, all about it. You have to specify the question really well. You have to debate the question a priori of the vote, and then, well, the people can decide. But Brexit taught us that stuff like good weather that people left for the weekend, and also there are certain lies and certain section of the society that's like, well, that yeah, and there are sections of the society who are really how to say, immune to any information or any informational campaign. As we can reconstruct, for example, the British history in the EU, they were campaigning from the 80s about the pros of their membership in the EU, and well, as you see, this idea, this point of view, never survived. So yeah, I think this, and as you mentioned, the rise of populism, well, and social media, well, this is all part of the bigger picture, and this is why I'm skeptic towards this instrument.
Watching TV, the opening of the new parliament, and a special attention was given to the national minorities. And therefore, I'm asking you if this recognition will go along still the non-territorial principle, because we always study this as an example. And I would like to know if something is going to change with respect to before. How is the situation nowadays in practice, if you know? If you can tell us something.
You mean the national minorities or?
Yeah, non-territorial autonomy, the personal autonomy. I mean, how the minorities can work within the council and so on at local level in Hungary. They don't use, yes, because we generally speak about personal or cultural personal autonomy.
I don't believe they have.
Okay, thank you.
Minorities, representation, even in the past.
Yes, we had a legislation. You mean the minorities represented in the parliament or local government?
At local government,
Local
maybe,
government.
yes.
Yes, they
Yeah.
have. They have. They can't have their own municipality.
Yes.
But that municipality. So, for example, we have Romani municipalities in several places.
Yes, this was the question.
In several places, but that was also manipulated, let's say that, because
Yes.
that was a direct financial connection between the urban government and the governmental level and the municipality. And in the Roman municipality, the local government has some kind of independency or had some kind of independency, but if that was Romani, for example, municipality, they had no.
Before closing the works of this forum, which was very interesting, in my opinion, I would like to say that we have the opportunity to publish your religions, which is something different from uploading reports on the EU Commission website, which is mandatory for this project, as you will know. If you want to elaborate your reports and transforming them in an article, academic article, we will publish in our journal. We have made different possibilities. So I would ask you if you are interested in, and when you will be able to finalize the text. It's not a question, but
I think it will be very worth to publish this text. Yes, I agree. But when exactly?
yeah.
Yeah, in my case, by the end of this year is possible. Yeah.
At the same time, beginning of the next year, around like January, February.
Oh,
It's supposed to publish the paper tomorrow.
Yesterday.
Yeah, I think so. Yeah, the end of the year would be fine.
Yeah, I have to discuss with the other two participants, but I think we would love to.
What year? We have to clarify what year we're talking about.
You know, maybe we look at the series of the papers or
Especially
Special.
online open access.
Okay.
Online journal.
Mhm.
You know what? I will come back to you with requirements, because requirements and deadlines.
Perfect.
These are very, very courageous students. Their presentation on participatory democracy. And these are two colleagues from the Faculty of Law at the same university. And Alessandro is one was best expert of Eastern and Central and Eastern Europe, especially and who knows many Polish, so that's and no other questions or I'd like to thank you very much for your participation, and I think that we'll see in the next seminar the next one will be in Bratislava, the 24th of August, and then I don't know the other meeting.
Yeah, I will be there.
No, yes, but then no, there is a Paris meeting in March, maybe
In Budapest.
In Budapest, yeah, fine.
Before Paris, there is something in Paris.
It will be deliberative table, let's say, so, but I don't know exactly that.
Okay.